Hi, everyone. Harry here. We are at the very crossroads between the pre-election period and the election, and we have what I think you could say our first lawsuit involving basic election procedures, the kinds of things we will be looking for, especially come Tuesday, election day. So it's in Georgia, and it's in a very important part of Georgia, Fulton County, which you recall from Fani Willis's lawsuit, and just in general, it's a very blue part of Georgia. And Fulton County has said, we're going to be open over the weekend. That's this past weekend. And if you've got an absentee ballot, you can come in and drop it off. And that prompted a lawsuit by Republicans because Georgia law says the period of advance voting shall end on the Friday immediately prior to the election. So you're not supposed to be having advance voting anymore, and that's the legal provision that is there. However, says the county, this is not advance voting anymore. There's a provision that says you can't do drop boxes when in-person early voting has ended. And we're not using drop boxes. All we're letting happen is people can drop off their absentee votes. That's not continuation of the kind of early voting that's been permitted, mail-in voting and drop boxes and the like. Okay, so it does seem to me their case is probably the Republican complaint basically tries to analogize to drop boxes and says we have this provision of law that bars them, and that really ought to mean, say the Republicans, that you can't just drop off your absentee ballot at the open precincts, which Fulton County has left open over the weekend. And so that's the claim, and it just seems to me under Georgia state law, it's a stretch. We will see. But it's really worth noting as we kind of prepare for what's coming our way starting Tuesday to understand the nature of the lawsuit. It is filed in federal court. Even though it is saying that the violation is of state law. What they're saying is Georgia law says you can't continue to accept these things because as of Friday, in-person early voting had to cease. And so really what the case concerns is a construction of state law on whether in-person early voting includes dropping off your absentee ballot. Fulton County says no. It seems to me that position ought to prevail. However, they are in federal court as the Republican Party, which we learned, by the way, when we were thinking of jury pools and recusal with Fani Willis, is a slightly more pro-Trump jury pool. And they are saying that having Fulton County accept absentee ballots over the weekend is a violation of the Equal Protection Clause of the U.S. Constitution. So because you're getting special privileges to voters of those counties in violation of state law, thus arbitrarily and disparately affecting voters and candidates in other counties. Okay, for veterans of election law wars, that claim, that court says stuff. First, the whole equal protection idea, where does that come from? Basically, Bush v. Gore in 2000, the whole argument was, if you're looking at chads, but you allow a hanging one here, and you don't allow it there and all kinds of stuff like that, there's equal protection claims. And indeed, it's often forgotten, but a couple of the liberals actually voted that there was an equal protection violation in Florida, the way they were going about doing things. So the majority could say 7 of us have agreed that there's a problem here, counting the equal protection. Now, really, that equal protection argument was something that I think the two progressives, I may be wrong, but I want to say Souter and Breyer, wanted to just have to serve up some kind of compromise as opposed to the complete ugly stink bomb that was the Bush v. Gore 5-person vote. So anyway, equal protection and federal equal protection as it applies to state law and how one county construes, that's a very sort of aggressive and potentially wide-ranging principle, and it suggests that the Republicans are ready to try to push on it in the coming days. And then it brings things into federal court. It states federal claims to potentially go up to the U.S. Supreme Court. So all in all, it is in that federal channel leading to the U.S. Supreme Court. So that's one big thing. And then the other, that arbitrarily and disparately affecting against voters in counties and other states, that also is the germ of a theory that the Supreme Court, at least the very conservative members of it, seem interested in potentially applying. And that would be, yes, the independent state legislature theory. And the idea of that theory is that when a state court not gets it wrong, but at least the way this is always stated, is so crazy in its construction of state law that it's like off the reservation in state law. Of course, the cases it's applied to really don't fit that description at all, but you can just say, oh my God, they've totally gone off the reservation. That gives rise to a federal constitutional issue because of the placement in the federal constitution potentially of the state legislators and the state electors. It's all pretty nutty. And where we've seen it rear its ugly head, including in a statement, just a statement, not even a dissent, by Gorsuch, Thomas, and Alito that they did in a case arising from Pennsylvania last week. It suggests their ability to really flex their muscles and have a very broad federal constitutional basis for invalidating state laws and state action as construed by state courts, things that really ought to be state business. But this is the kind of wormhole they have to try to get in. Okay, so the Georgia state law case itself doesn't look that strong to me. I'm not an expert in Georgia state law, but the idea that this is, in-person early voting, as a drop box would be, doesn't, I think, seems very strong under state law. But the big thing is the way the complaint is framed tells you the R's are, ready to run into state court and do a couple theories that would not have been very credible before, but they are with this Supreme Court potentially, both the equal protection violation by some counties versus others. And of course, there are always differences in how counties do different electoral stuff. That's the way it works in the U.S. system. And then second, even more potentially pernicious, the idea of this independent state legislature theory and striking down what a state court does under state law, finding that if it's too crazy, it's a violation of the federal Constitution. So this Republican lawsuit, I think, gives some real hints to what we may be looking at in the next several days. And then in addition, states its own claim that's important in Georgia, because if for some reason it were struck down, all these absentee votes over the weekend, remember Georgia, I just need 11,780 votes. It's going to be very close again. And any striking down of votes in a Democratic stronghold could have pivotal implications. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.